While the Centre versus Supreme Court over the appointments tussle is going on for quite a long time today, again, the Vice President of India inside the Parliament said that the NJAC bill was undone. It was the people's mandate which was undone, and it is something that would be reflected in the world democracy. I have with me senior advocate and also the Supreme Court Bar Association President, Mr. Vikas Singh. Sir, another comment from the Vice President of India. How do you see that, first of all?
Well, I don't agree with the Vice President that the Supreme Court does not have the power to annul a law. It is a well-settled proposition that ultimately whatever the Supreme Court feels is a correct interpretation of law, either by striking down a particular law or reading it down, is completely within the domain of the Supreme Court. So the general power of the Supreme Court, I think, is completely wrong to say that it can't be done. Whether in the facts of this case it should have been done or should not have been done is a different matter. And in this case, according to me, it was rightly done. Only thing is that the experience that we have seen, or that we saw how the Collegium system functioned after the judgment, is something which is which I can't justify. And to that extent, I have always maintained that they need to reinvent themselves. And I also maintain that actually the government can bring in a law to regulate the Collegium system, because that part of the NJAC which discuss the parameters for deciding the eligibility or the zone of consideration for elevation was not even discussed in the Supreme Court judgment. So that part can be definitely controlled by law if they are not ready to reinvent themselves. But ultimately, there has to be a very broad-based and a transparent method of selection, which ensures that merit is not compromised, and the Collegium doesn't end up, appointing people whom they know personally, which is not which is the only criteria today, and that should not be the criteria. Rather, they should look for the right names, try and find out. There should be some search committee to identify names. Because the way the higher judiciary is structured today, the lawyers who are really fit to be judges are earning much more than what the judges earn. So you need to request them and cajole them, encourage them to become judges, and that can be done only by a proper search committee and by identifying the right people and motivating them, rather than just appointing whoever you find in front of you and whom you know, and making them as judges.
So another thing is that this tussle is going on for a very long time. A bench says something about the timeline, the law minister says something, now the Vice President too is coming out. Where is the end to all of this?
So the end is that as of today, we are in a country which proudly claims to be governed by the rule of law, and I don't think the Vice President or anybody else can deny that. And the rule of the law is that whatever the Supreme Court has decided has to be obeyed. And if you feel that there is some improvement to be done, either you bring that improvement, make that effective, but till you don't bring any improvement, till you are not able to, either the Collegium system reinventing itself or the government bringing in a law to regulate the Collegium system, the decision of the Supreme Court has to be obeyed. And whenever a recommendation goes, it has to be notified, and this kind of impasse is not going to help this, the higher judiciary at all.
Last and final question before I let you go is, since we are talking about the Collegium system and the NJAC, first of all, what do you think was a better option, and do you think that there could be amalgamation of both of them, and then we can get a better structure out of it?
So, the amalgamation will be, according to me, if in the identification of names, the government is also involved, and once the identification is done or rather the eligibility is decided, or rather the zone of consideration is decided, that zone of consideration should be then left to the Collegium to decide. So that, according to me, will be the best system, where transparency comes in the Collegium system. People, the right people are considered for appointment and are actually appointed, rather than, people being appointed as, so to say, on the basis of the knowledge of the members of the Collegium. And we all know what is happening in the Collegium. They are doing basically their own juniors, their relatives, their caste men, And there is no effort, rather mostly there is no effort. Some collegiums have taken effort, and I know of them personally, that some judges go out of the way to identify good names. But those are rare. The general system prevailing is that you look for, trying to, do what you want your people to get appointed or to please somebody. The latest fad is that if the Supreme Court Collegium judge tells a High Court Chief Justice to consider a particular name, then that name goes through only because he is himself wanting to be elevated to the Supreme Court. And that's again very sad. If those kind of things continue to happen, the credibility of the system is completely getting eroded.
This was senior advocate Vikas Singh, who was speaking to us over what the Vice President has said over this whole debate that is going on the Collegium system and the judicial appointment. I am Ananya Bhatnagar with video journalist Raju for CNN News 18.